when he came in to see the judge, that sort of thing.
Yeah.
We were speeding.
Okay, I'll just introduce the interview.
All right.
Hi, my name is Tim Naftali. I'm director of the Richard Nixon Presidential Library and Museum in Yorba Linda, California. It's July 15th, 2008, and I have the honor and privilege to be interviewing Elder Todd Christofferson for the Richard Nixon Oral History Program. We are in Salt Lake City. Thank you, Elder Christofferson, for doing this with us today.
My pleasure to be with you, really.
Tell us how you were selected to be Judge Sirica's clerk and when.
Well, this was back in 1971, toward the end of 1971. It was my second year of law school at Duke University, and I'm sorry, third year. And this, you might know that this is the kind of, or the period of time when people are applying for jobs anywhere, but particularly clerkships, if you're interested in clerking for a federal judge or a state judge. And so I had sent out resumes and requests to judges in Denver and San Francisco and Washington. Those were all cities where I thought I wanted to locate later for legal practice following the clerkship. Judge Sirica called me in November of '71 and invited me to come up and meet him and see if it was a match, you know, if he was interviewing different candidates for law clerk for that coming year. That would be to start in the summer of '72. So we met. He happened to be sick that day, interestingly enough, and was at home, but still wanted to go forward with the interview. So his then current clerk, then serving, drove me out to his home. And he met me in his bathrobe, and we, I don't know, we hit it off. It just sort of, when personalities click, and we had a good interview, and I enjoyed it, and he seemed to as well. And it was just a few weeks later, he called and offered me the position, starting the next August of '72. So I was overjoyed. I obviously finished the year, graduated in May of '72 from law school there, and passed the North Carolina bar while I was waiting to go to work for him, and then moved up to Washington and started work in August of 1972. In the meantime, the Watergate break-in had occurred in June of that year, and the month after I arrived, September, the first indictments were handed up against those who had been arrested for the break-in at the Watergate offices of the Democratic National Committee. The Judge Sirica, was chief judge at the time. Given everybody else's workload, he assigned the case to himself, and from then on it was Watergate.
Could you tell us a little bit about his role regarding the grand jury? A grand jury was impaneled, I believe, in June of '72. What relationship did he have to the grand jury, the first Watergate grand jury?
Well, technically, the grand jury serves as an arm of the court and is under the supervision of the district court, and he, as chief judge for the District of Columbia district, would have been the ultimate authority that they would answer to. Day-to-day activities are conducted under the direction of the U.S. Attorney, who then was Earl Silbert in Washington, D.C., and so there was little interaction, if any, initially. In fact, probably not until a year later was the judge directly involved with the grand jury and bringing them into court and meeting them and giving them some instruction. But yeah, he certainly, under his authority, the grand jury is impaneled and set up, and they began their work at his direction, technically, but the U.S. Attorney carried forward their activities.
When you started working for him, what was your workload? What did he have you do?
Well, initially, he had a docket of cases, as all federal judges do, and there was quite a variety at the court level, trial court level. Motions for pending trials, or cases that are being developed, even, of course, trials were going on. come in, attorneys would come in during discovery and their trials with motions about that.
Tim, wait just a
variety.
second. We've got a little audio problem for some reason. Can we just pause for just a second?
Sure.
Let's resolve this audio.
Part-time clerk. The district judges, you want to go ahead, or?
Well, I don't think have you switched the?
We're rolling.
Okay, go ahead,
Okay.
please.
You had asked about the other cases and work that was going on. The judge had an antitrust case pending and some other things on his docket that motions were coming forward, and just the day-to-day kinds of activities that happen in trials and trial preparations. But once the Watergate indictments came down and things got rolling, most of that was reassigned. So after September, it was essentially Watergate.
Were you there was another clerk, he had another clerk?
Yeah,
to help?
district judges hire or permitted to hire one full-time clerk. At the appellate court level, it's 2, and the Supreme Court, I think, have 3 or 4. But there was a young man, Richard Azaro, who was also serving there during the same time I was, who was going to law school part-time and serving as clerk or assistant part-time clerk at the same time. And we did a lot together. The judge made full use of both of his clerks.
Please tell us a bit about the cast of characters. What was Earl Silber like in court?
He was very professional, and I think very able. I don't know where he is now, if he's continued on in private practice, I believe, but he and those working with him, I thought, from all my observation, did a very good job. And they were dealing with a lot of unknowns at the time. You know, they were trying to dig to the bottom of things, and they couldn't get there because of the cover-up that was the subject matter of the second trial a year and a half later. But I thought they did a good job getting as far as they could and uncovering as much as they could and going forward with the initial break-in trial, those who had financed directly and acted directly in the break-in at Watergate.
One important part of the story early on is that, at least it seems from Judge Sirica's book, is that the judge began to have doubts that the full story was coming out. Tell us a little bit what you can recall, because it's clear that he talked to you a lot. What you can recall about how his growing doubts about what he was learning and not learning in that early period for the sentencing.
Well, his great strength, I think, was his vast experience in trial work. He had started out, after graduating from Georgetown Law School, spending a lot of time in the police courts waiting for cases to be assigned to him. So he would just take whatever the judges would pass on as an indigent defendant and somebody who needed legal help. So he got kind of that nuts and bolts raw experience that few trial lawyers ever do, or few lawyers, period. And then he went on to the U.S. Attorney's Office there in the District of Columbia and was in trial work. And then at Hogan and Hartson, a large and prominent law firm there that, again, had him doing trial work. So he had seen it all, pretty much, and it was hard for anybody to pull the wool over his eyes as regards what's happening in the courtroom and when the truth is being told and when it's not, and so forth. He had this sixth sense, I guess, based on all that experience, that someone or ones were lying in his courtroom, and it drove him crazy. It infuriated him, really, that anybody would lie under oath in his courtroom. Anyone would commit perjury in his courtroom. He had a very finely honed sense of justice, and perjury goes to the heart of the whole legal system. If you can't get honest testimony, truthful testimony, then justice is at risk. So I was going to say it annoyed him, it infuriated him, really, that was happening. And I remember conversations in his chambers between sessions, and he would walk around, he'd pound the table, somebody's lying in my courtroom. And he had some ideas who it was. It turned out he had fingered the wrong person, but he was right. You know, some bodies were lying under oath. And what particularly gave him pause was the fact that these 4 Cuban Americans all of a sudden decided altogether to plead guilty and stop the trial proceedings as far as they were concerned, which he saw, and I think was true, was a way of whoever was masterminding, if somebody was, this lying or deceiving or cover-up, this was a way to further it, because it would deprive the court of their testimony and the public of their testimony, and as you know, that's what happened. But it was something that deeply concerned him. There's, you know, he couldn't control the events from the prosecutor's side or the investigator's side to try to get at the bottom of that, but he did intervene once in a while to ask some questions himself in the hope of getting the truth.
What effect did the coverage of the Watergate case have on, on his sense that you weren't getting to the bottom of this? You know, there were some stories in the Washington Post in that fall of 1972. Was he saying, well, look, this is coming out? Did that trigger some of his concerns or doubts?
Well, I suppose he, you know, he knew what was being said in public and the various, you know, opinions and pundits and so forth going back and forth. But I think the main thing was really his own sense of it, having had 40-plus years of experience in trial work.
What about his concerns about the role of the CIA, given that a number of the men in front of him, in fact, most of them, had a CIA background?
Well, there was some concern of that. In fact, I can't remember precisely when this was, but I guess it was around the time the trials were beginning, the initial trial. You may recall it was delayed somewhat because he had a back injury. Just strained his back and really wasn't able to sit very long. And so he had to postpone the trial from early fall to later in the year. In fact, it was after the election, and there were a lot of pundits who were saying, Sirica's in on this, you know, he's delayed the trial to make it easier for the president to get reelected, and you know, they thought he was trying to hide things. But it was simply just a physical injury matter, and so it was later after the election that the trial got underway, and some of these other things had come out about CIA connections, and I don't know if at that time something was being whispered about Patrick Gray, the FBI director, and a possible role he might have had somehow. But the judge began to get worried whether his own office was bugged and whether his courtroom and jury room were bugged and so forth. So he had them checked. He had it swept, as they say. Nothing was found, but he was a little uncertain. He would say at the beginning of each day, he'd call when he was coming into the courtroom building, court building, and parking in the garage under the court, and he'd say, meet me in the cafeteria. They had a cafeteria in the basement of that courthouse. And so I'd go down, and he'd have his coffee, and I'd have my chocolate milk, and we'd sit at a table there, and he said, well, they can't bug this place. And so we'd talk about the day's activities and what's going to happen next, and make plans for the course of that day in what he felt was a very public, therefore private setting.
Did he begin to sense that perhaps the White House was involved? When did he begin to sense that there was a higher conspiracy at work?
Well, I think in that first trial, he began to feel that there must be others. In fact, he became convinced of that because of the testimony, because of the guilty pleas of the Cuban Americans, because of what wasn't coming out, and you know, it didn't make sense that the mastermind here was Howard Hunt or Gordon Liddy, without anybody above them giving a green light to what they did. So he felt certain that there were others. He had no sense that it extended as far up as it did. There was no suspicion that President Nixon himself might have had any role in either authorizing or hiding what had been done. That just didn't enter his mind, I don't think, at that point. And it really wasn't until the White House tapes were produced and listened to that, that became, the opinion changed.
Let's talk about sentencing for a moment. What point do you think the judge decided to use his sentencing power as a way perhaps to open up the case a bit? Tell us about the conversations you may recall with him on that question.
Well, I remember sentencing decisions for him were always agonizing. He spoke about it. There were, I think during the time I was with him, from residuals from some of these earlier cases he had, came along where he was required to make or issue a sentence for somebody who'd been convicted or review a sentence. And he would agonize over those. He had a reputation among some of just throwing out maximum sentences and not caring about it. Got the nickname Maximum John from somebody. But he did care, and it weighed heavily on him to what was the right sentence in a given case, and the impact it would have on the person, on the man's family, or whatever the case might be. And he would say, I just, thoughts went through his mind like, how are the wife and children going to suffer? And then the thought would come into his mind, well, why didn't they think of that before they acted, and so forth. So this was true in Watergate as well, but there was this added dimension that you refer to, that he said, part of the sentence ought to be how willing and forthright, or willing to be forthright, these defendants are. As I say, he was convinced that the truth had not been fully disclosed. He felt certainly they had more to say, and he said to himself, I'll give a lighter sentence if somebody's willing to come forth and be honest and own up to what's gone on here. And so he did give these provisional sentences. And as you know, Jim McCord, one of those so sentenced provisionally, came forward with his letter saying, yes, there were others, and I know about it, and I'm willing to testify. Was
that innovative on the judge's part to give very high provisional sentences? I mean, was that commonly done?
No, I think the idea of the provisional sentence contingent on cooperation, as he did it, is not too common. I think typically that's something that's taken into account in sentencing, but it's usually after everything has happened. After a person has pled guilty or been convicted or testified or whatever. It's at the end of the process rather than in the middle, as it was in this case. And there were those in legal circles who were critical of that, saying, the incentive here is to make something up to get a lighter sentence. I mean, you may be creating disinformation instead of getting at the truth this way. And that's a risk, it's a valid point, that where someone is of a mind to do that in the hope of bettering their own situation, it could happen. In this case, it did not. I mean, the end result here in practice was it got at the truth. But the approach to sentencing, that approach to sentencing has its critics as well as defenders. It's worked appropriately here.
Do you recall any late nights looking at precedents while the judge was deciding whether to use the provisional sentencing route?
I don't know if we're late nights, but plenty of time spent analyzing that and looking, as you say, at the legal precedents. And he, of course, had seen this, and I don't know if he'd used it before or not, frankly. But it's not that it never happens. He'd seen it in his experience in the past. So He felt comfortable with it. It's not the kind of thing he did routinely, but in this case, he felt it was right.
Please tell us about the day that James McCord came to see the judge.
I can't remember the date exactly, but he appeared just himself, not his attorney, no one with him or in his behalf, but he personally just appeared in the judge's offices. And his secretary, judge's secretary, Elise Hawley, was there and received him. He said, well, I'd like to see the judge. I want to give him a letter. She dialed into the judge's office and informed him who was there and that Mr. McCord wanted to deliver a letter to him. The judge was, as you can imagine, very on guard about that instantly. He didn't want to have any ex parte contact with any of the defendants or their attorneys ex parte for that matter. It needed to be with all parties represented whenever there was anything done outside the courtroom. So he really didn't know what to do, how to do it. So he called into my office and said, you and Richard Azzaro talk to him and see what he has. So we went out to the reception area, visited with him for a minute, and persuaded him finally just to leave the letter and that we would see the judge got it, and thanked him for it, and he left. And so the judge then called in a court reporter and representatives from the U.S. Attorney's Office to come down when he opened the letter. I can't recall if McCord's lawyer was also invited in. I'm not sure about that, but he wanted to be sure that it was done in sort of a public way. That is, there was a record made, official record made of his opening the letter and reading it. So he did. He opened the letter in his office in the presence of Earl Silbert, and I think it was still Earl Silbert at that time, and others, and Rich Azzaro and myself, and read it onto the record. And then, I'm trying to remember now, I believe he delivered the original letter itself to the prosecutors for further investigation. Copy went up to the Senate Select Committee in their investigation. They immediately had McCord come in to testify there and say what he knew based on his disclosure in the letter. So that's what happened that day, an exciting moment.
It must have been. What I was wondering, I'd read one account that the judge was so concerned that someone might think he was concerned about being set up, that someone might think he was taking a bribe, that he had the letter sent via the parole board, so it would be delivered actually by somebody else and not McCord to him. So you actually
I think you're right. I think you're right. That was his idea. So we persuaded Rich Azzaro and I, you've refreshed my memory, persuaded him to go down and deliver it to the parole officer, who would then bring it up. In the meantime, the court reporter was summoned, the U.S. attorney and so forth, so that when he delivered the letter, we were all there. But
didn't the judge at one point ask Silbert to leave the room when he opened it? Or was Silbert in the room when he, I wasn't sure if he asked Silbert to go sit, the prosecutors to sit outside when he actually opened the letter.
He may have, I just don't remember.
Yeah, it's a long time
to be honest.
It's a long time ago. But what did the letter say?
Well, the gist of the content was, yes, Your Honor, there were others involved, higher-ups who directed this. As I recall, he said he could name them. I don't think he did in the letter, but stated that, yes, persons had committed perjury in the break-in trial. And, you know, he could point the finger and would do so if requested.
So how did the letter change the case for you? I mean, what were the implications for the judge and you of the letter?
Well, there were no immediate implications in the court. It moved the action very quickly to Capitol Hill, where those hearings were ongoing, the select committee that Sam Irvin was chairing. And that really broke open their investigation. It would later, mean that that they would come, they and the special prosecutor by that time, Archibald Cox. I guess part of that was that a special prosecutor was appointed, was one of the indirect results of that. But all of that generated a great deal of action in the Select Committee on Capitol Hill, and it was in the context of that Alexander Butterfield was one of the witnesses who testified that there were recordings of what had taken place in the Oval Office and meetings in some other locations and telephones in the White House. John Dean had been called up and he had given his testimony. All of this seemed to break open what had been to that point a fairly successful cover-up of things. But nothing much happened in the court itself other than the grand jury investigation continuing until the tapes issue arose and the special prosecutor Archibald Cox subpoenaed selected tapes, 9 different conversations that he was after. And later the select committee came in and wanted to do the same, but the focus was really on the grand jury subpoena, acting through Archibald Cox on the initial request for White House tapes.
I'd like to ask you a little bit about the effect of the creation of a special prosecutor. Was there a sense, and I apologize if this is not how it works, but was there a sense in the court that there would be another round of indictments from Silbert and his team in the spring of '73 before Archibald Cox came on board? Was there a sense they were close to indicting another layer above the Cubans and Liddy and Hunt?
I don't recall a sense that they were close to that, but that was where they were heading. And with McCord's letter and testimony, that had broken the logjam for them as well. And so their investigation was active. But by the time a special prosecutor was called in, I don't know how close they were, how close Earl Silbert and his group were to learning the full story or more of the story. But this change occurred. A special prosecutor called in and then put off the case before the existence of the tapes was made known, and perhaps before John Dean's testimony. I can't recall when those happened in time, but in relation to each other, but it was pretty close, right?
Well, John Dean is having his off-the-record conversations with the prosecutors in April. And of course, the special prosecutor doesn't start until May. So it's the McCord letter really starts accelerating events. But what?
Change tape read.
Okay.